Now we'll discuss the very provisions of breach of contract as widely provided from section 73 to 76 of Indian Contract Act. Generally, in a breach of contract, there are two parties, defaulting party and aggrieved party. And the very defaulting party is that party who does not perform his obligation or expressly refuses to perform. So the very remedies available under this breach of contract against the defaulting party or cancellation or rescission. So, for an instance or illustration, Mohan promises to sell certain goods to Sohan at Rs 1000, then refuses to deliver the goods on the same time or day. So now Sohan is free from the contract, so he can cancel or he can resign from the very contract that he raised with Mohan. And there are certain exceptions, and those exceptions are: one is express or tacit confirmation to perform the contract by the defaulting party, or secondly, entering of a third party to the very contract to lawfully to perform the whole or part of the contract. And the third exception, that the contract is not divisible. And the fourth exception, that is when circumstances change, no more possible to perform. So these are the exceptions available to the defaulting party under the remedies of cancellation or rescission. And now we'll go to the second remedy, that is claim for quantum meruit and the very essentials of quantum meruit. So it is a kind of compensation not decided in the contract, but it decided by law according to the circumstances of each case. So for illustration, a contractor was engaged by B to build a house at Rs 50 lakh. B abrogates the contract. So A can sue for damage, and the very quantum merit or compensation could be decided by the court. And the very essentials of claim for quantum merit are work necessary to be divisible as possible to estimate the compensation. That means that the work, that portion which is finished by the aggrieved party, and if it could be divisible, then it would be possible to estimate the very amount of compensation. And the second essential, which is that if the contract is not abrogated by the aggrieved party. So, for an illustration, A writer reach an agreement with B for publishing with the publisher to write a book. After writing 2 chapters, refused to complete the book. So, it is a kind of abrogation by the aggrieved party. So, these are the essentials we found regarding the claim for quantum meruit or the amount of compensation.